guest. I'm a little bit nervous.
Okay, that's fine. Nothing to be nervous about. Can we start with your statement? So there should be a file in front of you which says witness statement, and that is the statement at page 1 to 33. If you go to page 33, if you can confirm that that is your signature.
Confirm?
And just confirm that it was signed this morning, the 30th, not the 29th.
Confirm.
And do you confirm the correctness and truthfulness of the contents of the statement?
I do.
Okay. Now, there should be another file, which is file 10, exhibit file 10.
Correct.
Do you have that?
Yes.
And that is CJC 400, and it has sub-exhibits as well as exhibit numbers. And those are primarily the annexures or the documents that you refer to in your statement, correct? There are then other files in front of you, but that relates to the entire IDAC stream, which at some point we will get to some of those files, but primarily we'll be focusing on the documents in file 10.
Okay.
Thank you. And those are the documents that you have provided to the Commission as part of your witness statement, correct? Okay. Now, Chair, as you indicated earlier about the issue of Ms. Ramsamy being referred to as advocate, and she explained why that is, for purposes of her evidence, when we do get to those aspects where emails are addressed to her or referred to as advocate, we understand the context within which that is.
Yes.
Ms. Ramsamy, then if we can start with your witness statement, and if I could ask you here, please feel free to elaborate on your statement where you feel necessary, and we can start on page 1 of the statement at the introduction.
Thank you. I am an adult female admitted attorney in the full employ of the National Prosecuting Authority.
You'd have to raise your voice again.
Sorry.
Or bring the mic closer.
Can I bring the mic closer? There we go.
Yeah.
Can we do, is that better? I am an adult female, admitted attorney in the full-time employ of the National Prosecuting Authority, attached to the Investigating Directorate Against Corruption, commonly known as IDAC, which is established in terms of Section 7, subsection 1, capital A of the National Prosecuting Authority Act 1998, Act number 32 of 1998. I joined the IDAC as a state advocate on the 1st of March 2023. I hold an LLB degree obtained from the University of KwaZulu-Natal, and I was admitted as an attorney of the High Court of South Africa on the 7th of June 2013. I was appointed as an aspirant prosecutor in Pietermaritzburg, KwaZulu-Natal on the 1st of February 2015. I wanted to continue the I wanted to contribute to the justice system after a personal tragedy. What started off as a 2-year commitment as a prosecutor has turned out to be an 11-year journey. I was based within the Pinetown cluster, KwaZulu-Natal, from the period of 2016 to 2020. During this period, I've dealt with drug-related prosecution and worked closely with SAPS members such as Carl Saunders, who has given evidence before this commission. Thereafter, I was a regional court prosecutor, appointed as a state advocate on the 1st of March 2023 in the Investigating Directorate, IDAC, or which later became IDAC. Given the extensive nature of my evidence, I will submit 2 statements. The first statement being the statement which deals with the genesis of the crime intelligence investigations until my consultation with the complainant, Mr. Fadil Adams, on the 6th of January 2025. In the second statement, I will deal with the events that transpired after January 6, 2025, regarding my involvement in the crime intelligence investigations and the Medicare 24 investigation. If I may clarify with regards to the Medicare 24 investigation, the Commission will see emails and correspondence that relate to Tembisa. However, the Commission will also see that the documents that I've provided does not relate to Tembisa. It was just titled that under, my opinion is that it was a guise. It is, in fact, the Medicare 24 contract.
Can I just clarify on that? So later on, we will see handwritten notes from you of consultations that were held and meetings that were held where reference is made to SAP's contract, Tembisa Hospital. You say that that is, in fact, the Medicare 24 investigation or Medicare 24 matter. That is what the office referred to it as at the time.
Correct.
So the reference to Tembisa in emails is in the subject line.
Correct.
And who initiated emails referring to Tembisa?
Advocate Johnson.
Or then you then communicated in later emails still using that same subject line?
Correct. It later then, Advocate Johnson would title projects. Like the crime intelligence became known as Project Diversion, which I explain in my affidavit.
You do explain in the statement, yeah.
In my second statement, you would see that what was initially titled as Tembisa, which was actually the Medicare 24, becomes Project Wellness.
All right.
So
No, thank you.
it progresses in terms of names and disguising.
Thank you, thank you.
Is an explanation given why it's called Tembisa? Why you are using that title?
Like I said, my understanding is that it was initially to disguise what was actually being investigated. Because I myself was confused, and through the WhatsApps that the Commission will see, there are articles that I sent based on the Tembisa to Advocate Johnson. It's only later towards May that Advocate Johnson openly stated that it was the Medicare. But in meetings with the team, we were aware that it was a 360 million rand contract.
Which is the Medicare 24 contract.
Correct.
Okay, thank you. Then this next topic is the personal impact of the Commission.
Thank you. Before I testify regarding my involvement in the matter relating to IDEC that I have been asked to testify about, I have to set the record straight at the onset regarding Advocate Andrea Johnson's testimony before the Commission. Advocate Johnson told many untruths about me and my involvement in what is now known as the Mukwele case. She did not disclose that I raised concerns from the onset and repeatedly thereafter, which concerns I deal with in detail. These concerns are not limited to the Mukwele matter. I had concerns about the crime intelligence-related cases and matters relating to the National Commissioner, General Fani Masiamola. Advocate Johnson decided shortly after the Section 2813 authorization of the crime intelligence matters that all other crime intelligence matters would be ring-fenced into a project which she named Project Diversion. I do not know why she chose this name, other than that what is stated in the WhatsApps that I have provided.
Which we will get to in the chronology of events.
Correct.
Okay, the next page, for paragraph 5.
Thank you. I am profoundly disturbed but not surprised by Advocate Johnson's testimony. She sought to blame me for so-called irregular or problematic processes. Let me make it clear that Advocate Johnson was in charge of Project Diversion, and in particular the Mukwele matter from the onset. I deal later with the makeup of the team, which was different to how a project or investigation team is usually constituted. It is my belief that Advocate Johnson handpicked me to be part of this project because I had successfully, or rather we had successfully investigated another Section 27 referral matter involving a high-profile individual. I also believe that Advocate Johnson picked me because she thought that I would not question or ask questions because I'm a state advocate, not a senior state advocate, not a deputy director of public prosecutions. What she did not anticipate was that Mr. Mansa Rapesu, the lead investigator, and I would question Project Diversion from the start. May I proceed? Thank you.
Continue.
Thank you. I confirm that I prepared documents on Advocate Johnson's instructions instructions that were one, not in accordance with IDAC's standard operating procedures, which Advocate Johnson indicated to this commission did not exist. 2, the process followed in July 2023 referral. And 3, that went against my concerns when assessing the merits of the complaints by Mr. Adams. I refer in particular to the application for authorization of Section 2813 investigation that I prepared on the 5th of December 2024.
Sorry, can I just interject there to deal with the issue of the standard operating procedure, which you deal with in that paragraph, which you say Advocate Johnson said does not exist. If we could ask the commissioners to go to file 10 and page 9, which is, if you can identify that document for us, and the signature on page 10.
Page 9 is the Investigating Directorate Against Corruption Operations Manual. This is disseminated via email to every person that works at IDAC. It is also re-disseminated to every staff member upon the arrival of a new staff member. So it cannot be said that there are no operating procedures or SOPs within IDAC. The
And then-
signature,
Page 10, yes.
page 10.
Page 10, it should be page 10. You were on 9, which was the first page of the and then page 10.
The last paragraph or portion of that page 10 is the signature of Mr. Matthew Sissoko. He is the head of investigations and operations, also known as the second in charge of our office. And then thereafter is the signature of Advocate A. Johnson, Investigating Director IDAC. Please note that the dates also indicate 16 October 2024. This is version 2.
Yes, we can see there that version 1 is 18 December 2023, and then version 2, 16 October 2024.
Correct.
And could you just briefly tell us what the operations manual deals with? We are going to deal with it in detail later when we engage you on the processes, but if you could just give us a high-level summary of the document for now.
The operational manual.
Sorry, Ms.
Am I speaking
Ramsamy,
too
yes,
softly?
and
I apologize.
closer,
Okay.
yes.
The operational manual is supposed to, and I use the word very, supposed to, create structures in which the IDAC works. These structures are based in terms of Section 7 and 27, 28, and 29 of the NPA Act. It sets out procedures with regards to investigations, referrals from the NDPP, team constitutions, reporting lines, presentations, instructions on how presentations are supposed to be done, on briefings as and when investigations are in progress. Basically, it's the Bible of how a structure of our nature is, or IDAC's nature is supposed to work. And when I use the word supposedly, if I may, Advocate Siegel, continue, thank you. Advocate Johnson would deviate constantly. It was a situation where we had this, but she would also have her own way of doing things with different groups, different investigations, different structures. So there was a constant deviation from what was in black and white. And it was always from her office that the deviation was done. And when the deviation was done, it always came with intimidation.
Can you explain intimidation in this context?
Am I allowed to say it as we say it in the office?
Yes, please.
The nickname for Advocate Johnson in the office is flip-flop, knee-jerk.
Okay, just explain that.
You would get instructions in the morning. Can I speak from my personal experience now? Okay.
Yes, please.
You would get instructions, or you would have a conversation with Advocate Johnson in the morning, or telephonically, or via WhatsApp. And it would be just the two of you, or maybe another prosecutor and you. And you would find commonality, or you would explain the legalities, the processes. I mean, the elements of an offense changes, but the principles of law does not change. If you have a document in a murder matter, it doesn't change when you're trying to prove it in a corruption matter. So you would have those engagements with her. And then during the course of the day, there would be a conversation that would take place between Mr. Perumal and Dylan Perumal and Advocate Johnson. And the flip-flop would happen. So no matter how you explained it to her or how the decision was made in a rational manner, it would then change according to what Mr. Perumal wanted. And my evidence will show how that affected the investigations.
And when you were engaging Advocate Johnson without Mr. Perumal, did you find that you were then speaking to somebody that was legally trained, a prosecutor? Was there that level of engagement?
Yes. When Mr. Perumal was not present or was not involved in the communication or was not influencing the decisions, Advocate Johnson was a very active legal mind. You would be able to engage, and she would speak about different things that she had done and how we can incorporate it and sections of acts. But then come Mr. Perumal, all of that is thrown out the door. And we are now doing things that we're not even supposed to be doing. And it is becoming an instruction. And Chair, from 2023, let me speak for me rather. No, I'm going to speak collectively as the prosecutors of IDAC, because we are all, majority of us are rocking in this boat. If you defy an instruction of Advocate Johnson, or you contradict her, the reign or the wrath, if you have to, may I speak about, if you have to go and check the records at the wellness program that NPA provides for its employees with regards to just work stress, home stress, counseling, you will be shocked at the amount of prosecutors and employees, admin staff from IDAC that are receiving counseling.
Is that not because of the nature of the work you do? Just explain.
No, Commissioner.
Yeah, please explain.
May I deviate? Am I allowed to deviate?
Slightly.
Slightly,
Yes.
okay. If you don't follow the instructions, you receive emails of a nature that, when I was consulting with the DPCI officer, when I intended on making protected disclosure in June last year, I likened it to being treated worse than scullery maid. You would be internally investigated, unlawfully so. You would be made, I was made redundant for an entire period in 2023 because I objected to Mr. Perumal and Advocate Johnson. And it happened again this year because I objected.
And when you say internal investigations, what mechanisms would she adopt?
Okay, now I'm jumping ahead of my evidence, I apologize. Section 28 does not have any checks and balances. And it can be likened to a 205, a Section 205 of the Criminal Procedure Act. It's invasive. It's exceptionally invasive. But Section 205 of the Criminal Procedure Act allows for a person to make submissions to a magistrate or a judge to explain why we are now invading this person's privacy or we need this information. Section 28 allows unlimited control by one person without any checks or balances. And that is how we were investigated, through that.
Except, of course, that even if in Section 28 itself there may be no specific provisions, the Constitution is an overarching document. So Section 28 would still have to be applied with the Constitution or the privacy right in mind, if you see what I mean.
Correct, and
Yes.
my evidence, not very far down the pages, does deal with how this is so severely abused and how it continued since my start at the ID to be sorry, Advocate Zipho.
No, that's fine.
Still on this, on the operations manual, the impression, I don't know if it's just me, but the impression that I gained from Advocate Johnson's evidence about this, the existence and application of an operations manual, was that yes, there is such a document, but we don't operate according to it. So the impression I had was, it's sitting somewhere in a computer or on your mainframe, but in fact, it's more, you just go about doing your things and people exercise their discretion at any one time in meetings without this ever being applied. Is that correct? Because you speak of it as a deviation. In your testimony, you say she deviated from what this prescribed. Is that deviation as a matter of course? That's what happened, and therefore this was just good on paper for all intents and purposes.
It's applied as and when Advocate Johnson wanted to use it.
All right, I'm answered. Thank you.
Okay, we can go back to your statement, paragraph 6. The 6th line, the sentence that starts, I will explain. I will explain why this did not sit well with me.
Page 3.
Yes, page 3, paragraph 6. You'll see after you deal with the 3 points, you then say, I refer in particular to the application for authorization. Do you have that?
Yes.
You can read from there.
I refer in particular to the application for authorization of a Section 2813 investigation that I prepared on the 5th of December 2024. I will explain why this did not sit well with me. However, the commissioners must bear in mind that at this point, Advocate Johnson had stated they had made a decision that the matter was to proceed in terms of Section 2830, and that I was to draft the authorization and email it to her on the same day that the referral was handed to me, because she wanted to approve it by Friday, the 6th of December 2024. I deal with this fully later in the statement.
Continue.
On or about the 30th of June 2025, after the Mokwela arrest and the first appearance, I contacted a DPCI officer. I must state I trust this DPCI officer, which is why I contacted him, to inform him that there's a problem at IDAC and that I need to see him and explain and show him the documentation that I had in my possession. I asked if I could if I could do protected disclosure. We agreed to meet on the 2nd of July 2025, where I showed him a prosecutorial memo prepared by me and another prosecutor regarding the matter of General Masiamula and Lieutenant General Kumalo, which I deal with later. He said that he would speak to a colonel at the DPC